Hi, everyone. Thank you for joining us today for Constangy's webinar, Buckle Up, California 2024 is just around the corner. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenters will leave time to answer your questions. This program is pending Sherman HRCI credit, and we are also offering California CLE credit. We will be sharing the Sherman HRCI codes at the end of this presentation, so please stick around in order to get those. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow morning. Today's presenters are Lara and Carolyn. Lara is an experienced trial lawyer and client advocate. Her extensive career has involved representing companies of all sizes across many industries in all aspects of employment law. Lara has successfully defended clients in the courtroom before administrative agencies and on appeal. In addition to litigation, Lara has spent her 2+ decades of experience partnering with clients to counsel them through complex issues involving discrimination, retaliation, accommodation, and wage and hour compliance. Lara has also developed a passion for guiding clients through high-stakes matters involving pay equity, harassment, leave of absence, and accommodation. Lara has had the distinct experience of working as in-house counsel for 2 large multinational corporations, which gives her a unique perspective on how to address the intricate issues facing organizations and their employees. Carolyn represents management in a wide range of matters involving wage and hour disputes, class action litigation, wrongful termination, discrimination, and harassment claims, and appellate matters. Carolyn also has extensive experience representing plaintiffs and defendants in contract disputes and trade secrets litigation. She has also defended corporate clients in litigation involving business torts, unfair business practices, and consumer class action claims. In addition to her litigation practice, Carolyn provides counseling and advice to employers regarding restrictive covenants and protection of trade secrets. I'm now going to turn it over to Lara and Carolyn.
Thank you so much. Hello, everybody. Happy November. We are very excited to talk to you today about a large amount of new developments in California. A lot of new statutes or new laws were passed or amended that are going to be going into effect come January or later. And we've got a lot of exciting cases that are coming down the pipe with our California Supreme Court. So we have quite a bit of information to cover today. So I'm going to get started talking about our legislative developments. And I will tell you guys that a lot of these new changes are pretty complex, and our slides have a lot more detail than we tend to have. And that is so it can be a reference point for you going forward once you get the materials from today. So pardon us in advance if we don't go through everything word for word, but we wanted to make sure that you guys all had some sort of a resource or reference to go to once today's webinar is over. So in our first category of issues that the legislature dealt with this year, as we see some changes with respect to kind of your typical FEHA, discrimination, harassment, and retaliation claims. The first bill that I wanted to talk about today deals with employment discrimination in cannabis use. And if you're having a little bit of a sense on deja vu, it is because we had some changes last year with respect to this topic, where the changes weren't going to become effective till January 1, 2024. Well, now we are on the cusp of January 1, 2024, and the legislature tinkered with that law from last year and enacted, and Governor Newsom signed, what is SB 700, where it prohibits the discrimination on prior cannabis use. So first off, what it does is it says it's unlawful for an employer to request information from a job applicant relating to their prior use of cannabis. And then also, if an employer obtains information from the criminal history report about cannabis use, the employer might be limited in how it can consider or inquire about that. So if you just kind of remember again from last year, an employer cannot discriminate against an applicant or an employee based on their off-the-job use of cannabis in the workplace. And there are some little exceptions to that. You also can't discriminate if there is an employer-required drug screening test that found that the individual had non-psychoactive cannabis metabolites in their body. So something to think about here with respect to your background check policies and procedures and your application of your drug-free workplace policy. Now, you will recall, if you recall from last year, this does not change if you have a drug and alcohol-free workplace policy or other exceptions to this. You are still allowed to implement that. But you can refer to some of our notes from last year on that as well. On the retaliation front, this is kind of interesting here. The legislature has enacted a rebuttable presumption that an employer has retaliated against an individual if that employment decision occurs within 90 days of the employee's protected conduct. So SB 497 amends section 1197.5 and 98.6 of the Labor Code, creating this rebuttable presumption. It also amends section 1102.5, which is our generalized retaliation, anti-retaliation whistleblower protection for private employers. Y'all might recall that 1102.5 comes with a civil penalty of $10,000 in addition to allowing kind of the full, spate of different types of damages like economic damages and emotional distress damages, et cetera. So there's this $10,000 fine or penalty that can be assessed. The Labor Code was amended to clarify that this $10,000 is per employee and the employee is the one who gets it, as opposed to, the labor agency or anything like that. Now, it also requires, in the instance of a labor commissioner actually assessing the penalty, to consider different factors like the nature and seriousness of the violation, the type of violation, et cetera, as well as other things. So this is just yet, we've kind of seen over the past several years a real strengthening of our anti-retaliation statutes in California, going from changing, the burden of proof, now up to this rebuttable presumption for retaliation. So it just shows that this is really one of those areas of law that we need to pay very close attention to, not just in defending lawsuits, but also when we are advising folks on this, we need to definitely pay attention to issues of timing with that. The next topic we wanted to talk about, and kind of falls under the discrimination category, deals with background check procedures. And this is more of a public service announcement. This is actually, these regulations became effective October 21st of this year, but it was something that kind of fell under the radar, I think, for a lot of employers, where we actually had some regulations to our California Fair Chance Act. And there was the Civil Rights Council, the Civil Rights Department implemented regulations, again, that became effective October 1st of this year. It really just expands out the application of the California Fair Chance Act, which is known as our Ban the Box Act, which limits pre-employment inquiries into background checks, and then also what an employer needs to do when evaluating whether a criminal background would prohibit someone from employment. So a few things that I wanted to point out from this, for those of you who in particular have not yet thought about this, is first off, these regulations expand the definition of an applicant to include not just an actual job applicant or an employee who is applying for another job with the organization, but clarifies that it also includes an employee who might go through a background check when there's like a change in control agreement or a change in ownership, or even if there's some sort of a change in policy or practice that might cause you to want to go through a different background check. So that is a big change there. It also expands the definition of employer to include not just kind of the direct employing entity, but also other entities that might act as agents or evaluating a criminal history on behalf of the employer, staffing agencies or entities obtaining workers from a pool or availability list. So this would meaning it applies to your background check vendors, or if you engage a third party to evaluate whether or not someone is disqualified from employment for you, they would also be held responsible for complying with the statute. It also indicates, the regulations indicate that job advertisements or similar materials can't state that persons with criminal history won't be considered for hire. Honestly, if y'all are still doing that, you shouldn't anyway. But certainly now that this is in place, we want to ensure that our job postings do not include that sort of information. Again, that they are thinking that it has a chilling effect on individuals who might otherwise be qualified for a job, and they might not get that second chance to apply for and be considered qualified for employment. The regulations also state that even if the applicant volunteers information about their criminal history, you still cannot consider that and whether to issue a conditional offer. And then with respect to the individualized assessment, the ban the box law has or encourages employers to consider at a minimum 3 different types of factors when evaluating whether or not someone is going to be prohibited from employment because of their criminal background. Well, now under the regulations, it's requiring employers to take into account a number of other different factors as well, or it really just kind of elaborates or blows out these factors for things to consider. So you'll want to take a look at those and ensure that if you have a written policy or a written procedure in place that says we're going to be identifying these factors when determining these issues, that they're updated to reflect these additional factors, like the degree of harm, the permanence of harm, the context in which the offense occurred, et cetera. There's actually quite a long list of these factors that you'll want to look at and include and ensure that your group is actually taking those into account. And then the last issue here is that, when you make a potential decision that you're going to disqualify someone from employment, you need to send them a pre-adverse action letter. Now, the content of that letter does not need to change necessarily, except that under the regulations, an employee is now to be given 5 business days from receipt of the letter to respond to the pre-adverse action notice. So you want to make sure your timeline and your communications reflect that. So moving on to leaves of absence, we did have one change that we're seeing with respect to leaves of absence, where the legislature did include a new type of protected leave based on reproductive loss. So this adds a new section to our government code, and this would provide up to 5 days of reproductive loss leave following a, quote, reproductive loss event, which is defined as a failed adoption, a failed surrogacy, miscarriage, stillbirth, or an unsuccessful assisted reproduction. So this applies to employers with 5 or more employees. The employee must be working there for at least 30 days. If there are multiple reproductive loss events, which can certainly happen within a year's period, particularly if someone is going through assisted reproduction or IVF, the employee is entitled to only a maximum of 20 days in a 12-month period. So that would give them at max 4 reproductive loss events for which they would be entitled to this time away. These leave rights are in addition to SIFRA and FEHA, so under like the PDL or something. So keep that in mind as well. And the leave must be taken within either 3 months of the reproductive loss event or within 3 months of the end of the SIFRA or other protected leave if those are taken. So if we thought dealing with pregnancy and maternal care was super complicated under California law, it is now even more complicated when we take into account these other issues, particularly when we think about, SIFRA or PDL, or even on the federal landscape with FMLA leave or, potential leave as an accommodation under the Pregnant Workers Fairness Act. We now have this type of situation too, which we need to factor into the mix. So be prepared for that. As for pay, the leave is generally unpaid, but employees can opt to use vacation, personal time, or sick pay for it. And then we have our kind of standard don't retaliate against employees who are availing themselves of this type of leave. And then also you have a confidentiality obligation with respect to that as well. So moving on to paid sick leave, and I have to tell you, I've seen just a lot of concern, consternation, worry about the changes to the paid sick leave law. And I'm not going to lie, paid sick leave is still, as you all probably know, a very complicated area. I think mostly because there are just so many different scenarios in which they can apply. There are so many different alternative ways that an employer can implement paid sick leave for themselves. Not to mention we have different ordinances which are layered on top of everything, which can make compliance a real standard. I mean, a real challenge for us. I will try to give some comfort, though, that if you actually take a look at the redlined law, and you can get that available on the legislature's website where they'll redline the changes that the amendments have made, not a lot has really changed, except for the amounts of paid sick leave available. So I have this sort of eye chart here where I'll go through some of the big details of the changes, but then the next 2 slides are actually summary charts. That hopefully for those of you who are visual might help you try to make sense of it. But all that is to say, by January 1, we do need to be looking at our paid sick leave. We do need to ensure that our processes and like the back end kind of functionalities that help us accrue for our paid sick leave, accurately report them on our pay stubs, and proper notices, et cetera, are given to employees. So we still have some time to do that, but you should focus your efforts on that before Jan 1. But so under SB 616, main thing that it does, it expands the amount of paid sick leave that an employee is entitled to from 3 days or 24 hours to 5 days or 40 hours. Okay, period, stop. That's kind of like the main thing. All right. Now, as you might recall, under the paid sick leave rules, you can either front load or you can allow for the paid sick leave to be accrued over time. So there are some other provisions relating to that. So first off, the employee must be eligible to earn at least 5 days or 40 hours of sick leave or paid time off if you're using your paid time off policy to meet your obligations under PSL. But the employee must be eligible to learn at least 5 days or 40 hours within 6 months of employment. So you want to make sure that your accrual rate will meet that requirement. The amendments also increase the accrual caps from 6 days or 48 hours to 10 days or 80 hours. So if you recall, employees if you provide a PSL on an accrual basis, employees are allowed to carry over a certain number of hours or days up until a certain cap. Well, that cap has now been increased, which makes sense because the total allotment has increased as well. So that is increased to 5 days or 40 hours in each year of employment. Then there are some other provisions regarding the alternate sick leave accrual method. If you usually, at least under the prior version, it was 1 hour of paid sick for every 30 hours worked. Employers in certain instances were allowed to use a different accrual method. So this imposes an obligation on that, which will become more clear on the next slide, actually, for that alternative method of accrual. Now, one thing that a couple interesting things here is you might recall that employees who are governed by a collective bargaining agreement were excluded from paid sick if their collective bargaining agreement met certain qualifications. Well, this amendments actually extend certain procedural requirements and the retaliation prohibition to employees who are operating under a collective bargaining agreement. So you definitely want to pay attention to that if you have any unionized employees, because that is a change for you. And then there is a preemption in there. And at first, I'll be honest, when I first heard there was a preemption, I got kind of excited because I thought, wow, this is going to make it super easy for people who operate throughout the state and have to deal with certain ordinances. However, the preemption is only related to certain certain of the more ministerial aspects that are addressed in the provision. So it's not a wholesale preemption, unfortunately. I'm sorry, but it is a little bit of a preemption. So we made this chart for everyone that talks about, the particular topic, the current state of the law, and then what we have are the provisions that are effective January 1 of 2024. So you can take a look at that after our presentation here, where, and here's the provision I was talking about with the unionized employees. And then we had also the alternate method of accrual, where you can see those requirements in there as well. So hopefully that'll be a useful chart for everyone to follow as you're updating your policies for next year. Now to kind of give yourselves a little bit of respite from this craziness, okay, what stays the same besides these numbers? All right, pretty much everything else stays the same. You still don't have to pay out unused PSL and termination. You still need to reinstate unused PSL to an employee who leaves but then comes back within 12 months, unless we cash them out at the time of their termination. You still have the discretion to advance PSL accruals that the employee hasn't obtained yet. Obviously that's something within your discretion. The notice requirements on the taking a PSL and the documentation requirements or lack thereof are still in place. Calculating timing is still the same, as are the documentation requirements about listing the PSL on an itemized pay stub or a separate writing provided each payday. So a lot stays the same to sum up. Some little things are different. This is a very detailed, complex law, especially if you have one of those policies that takes advantage of some of the alternate accruals, or you're trying to do this balance with multiple different ordinances as well. So definitely is something to start working on for next year. Shifting gears to workplace violence and employee safety. We have a new requirement under the the Cal OSHA, under that provision of the labor code, that requires an employer to establish, implement, and maintain an effective workplace violence prevention plan. And this is SB 553. Now, I'll say the vast majority of SB 553 actually deals with the last point that I have on this slide, which involves provisions for an employer or a collective bargaining representative to obtain a temporary restraining order on behalf of an employee or group of employees who are facing threats at work. So just a lot of those changes in that bill relate to that procedure and what a court may or may not consider when granting such a TRO. But going back to the workplace violence prevention plan that employers need to have in place, There are many details that are contained in that in the statute. So in addition to implementing and maintaining this workplace violence prevention plan, employers will now be also required to keep logs or a record of any violent incident for every type of workplace violent incident. And the statute actually categorizes workplace violent incidents into 4 different types of categories that you would need to maintain and eventually make available were you to be, subject to an audit or an investigation on this. Employers also need to provide effective training to employees on the workplace violence prevention plan and provide additional training when a new or previously unrecognized workplace violence hazard has been identified or when changes have been made to the plan. So yay, additional training obligations. But it really is for a good, I think for a good reason. And then in addition, I mentioned you have to maintain a log of workplace violence incidences, but you also have to maintain other records of any incident investigation, or if a hazard has been identified, what sort of evaluation and correction was done in response to that. So that is something you should work probably with your safety and security department on ensuring that you're taking steps or they're taking steps to have that in place and kicked off for the next year. So our next category are contracts in restraint of trade, aka non-compete agreements. And since Carolyn is our resident expert in this area, she's going to talk to you guys about these 2 bills that are going to become effective.
Thanks, Lara. And just so you know, we have been receiving questions in the chat box, and we will get to those at the end of the presentation. Okay. So thank you for your questions. Now, as far as the non-competes are concerned, I know this for those of you who do have non-solicitation and restrictive covenants in various employment agreements, this area of law is fraught and full of uncertainty. And the legislature has attempted to try to bring some clarity. And they have clarified some things and at the same time have made things a little bit more unclear. But one thing is clear, and that is that non-competes are not allowed in California, no matter how an employer tries to get around it. And so the BNP 16600 is the statute that makes void any contract that prevents anyone from engaging in a lawful profession, trade, or business. It has 3 statutory exemptions where non-competes are allowed: the sale of a business, the dissolution of a partnership, or the dissolution or termination of interests in a limited liability company. Those situations are fairly rare. And so, the legislature, in order to stop employers from including non-competes, because oftentimes they are included as a manner of warning to the employees, even if they're not necessarily enforceable. The legislature has said that these are not allowed. And moreover, it doesn't matter where the employee signed the agreement. So, for example, if the employee was working formerly in a state that did allow non-competes and signed a non-compete agreement with that former employer, if that employee moves to California, the former employer will not be able to enforce the non-compete against the now California resident employee or former employee. So that's something that's new, and that because the previously employers tried to take advantage of the form selection clauses in various non-compete agreements in order to enforce them. The next thing is that 699 does allow for a private right of action now. And that is a pretty serious thing, because before 16600 was only used as part of a declaratory relief action, and now an employee can sue for damages and have a private right of action, and if they prevail, then there's an attorney's fees to the prevailing party provision. Next slide. It wasn't clear until only recently that the legislature was also going to sign off on AB 1076. Now, AB 1076 is a codification of the 2008 California Supreme Court decision in Edwards versus Arthur Anderson LLP. Which is a very old decision. It's been around, and folks have tried to, it specifically deals with non-competes, but it didn't really address directly non-solicitation provisions. So in a way, 1076 is not too much different from already existing law, but in case the employers were unclear about non-competes in California, the legislature felt it was necessary to pass this law, AB 1076, to further solidify the Edwards versus Arthur Anderson decision. And moreover, this 1076 new law requires employers to notify current and former employees in writing by February 14, 2024, that any non-compete agreements they had reached are now void. So the notice is required to be sent to the last known address and email address of former employees. So that further solidifies that non-competes are not allowed in California. It's query as to what the situation is regarding non-solicitation of employees provisions and non-solicitation of clients based on the use of trade secrets to solicit. I think that at this point now, it's very risky to include those provisions. But one thing about this area of law is that it's very fact-based. And so each kind of situation requires its own analysis as to the risks of including such restrictive covenants in the agreements. Okay, and that's it. You're muted, Lara.
Thank you. I was going to say there are now a number of industry-specific laws that we wanted to highlight for those of you who might be applicable to, or if anything, you've probably heard a lot about these, because we've definitely seen a lot of commentary and discussion happening on some of these industry-specific laws. The first one deals with hospitality workers, and you might remember back in 2021, kind of during COVID era, California passed a law that talked about the rehiring of laid off employees in the hospitality industry, which was very specifically, a very specific group of employers. And they had a right of recall if they were laid off due to the downturn in business, due to the COVID-19 pandemic. And then the employer was starting to rehire again and was rebounding. These employees had a right to recall. And certain provisions needed to be followed in terms of notification and timing and of that nature. Last year, those provisions were extended until December 31st, 2024, and now it has been extended another year, where the law will be repealed December 31st of 2025. So we are seeing a little bit more of a hangover with respect to this particular provision. Now, it also expands a little bit of the recall right. So if you're in this space, you definitely want to pay attention to this. It expands the recall rights to anyone who was employed for at least 6 months and whose most recent separation of employment occurred on or after March 4th of 2020. And I have to imagine that there is a specific industry that was contemplated in terms of providing the rationale for the extension of this particular provision, because the further away we get from 2020, the more we tend to kind of think we've all kind of moved past it and we've rebounded and most things are back to normal. But if you've got folks that were laid off as part of the pandemic, this will apply to you and apply to them. Now, the amendment also does create a rebuttable presumption for anyone who was separated due to lack of business or a RIF, that they were separated because of the pandemic. We have seen quite a bit about healthcare worker minimum wage being raised. And this is a very broad, SB 525 provided some pretty broad relief to employees in this sector in terms of mandating an increase to the minimum wage for these employees. And it can be kind of complicated. I think what's probably more complicated about these provision is if you are in the healthcare space, identifying which schedule applies to you. Because there are 5 different schedules depending on the nature of the employer, the size of the employer, and then there are also specific provisions about who's included as a healthcare employee and who's not included as a healthcare employee. I mean, obviously those involved in clinical care, are healthcare employees, but then there are some adjacent roles as well that are included in the definition of who is covered by these minimum wage changes. So we have some charts on the next couple slides as well for those of you for whom this is applicable. But one thing we wanted to call out and have you specifically remember is that if you have exempt employees, which I'm sure you do, that the salary basis will be under that salary basis test and the minimum salary requirements for those employees, you're going to want to audit or look at those salaries because you might need to adjust those upward in order to ensure that they meet or exceed the minimum threshold based on these new schedules. So remember that to be qualified as exempt, the employee has to earn a monthly salary that's at least or no less than 150% of the minimum wage or 200% of the applicable minimum wage, whichever is greater. So you'll want to definitely take a look at those and ensure that you're calibrating or classifying correctly. Now the DLSC and the DHS are going to be developing a waiver program, TBD on that, to see what would be required of that program and how to apply for it if you want to receive an alternative phase-in schedule of these minimum wage requirements. So just to net this out, and again, to ensure that we have enough time to cover some of the other important developments, the bigger employers kind of bottom line is minimum wage starting in June 1 of 2024. I should have said that. So you've got a little bit of time to assess this and evaluate this. But it'll go up to $23 an hour, and then June 1 of 2025, it'll go up to $24 an hour, and then in June 1 of 2026, it'll go up to $25 an hour, and that is in place for these particular covered employers that have more than 10,000 full-time equivalent employees. So these are the really, significant or larger employers. As far as others, we have some provisions for hospitals or facilities that are, have, Medicare, Medicaid patients or rural or in smaller counties. You can see that it's only $18 an hour with a 3.5 annual increase. And then in 2033, yes, that's not a typo, 2033, 10 years from now, it'll be $25 an hour. And then you can see here we have the other schedules for these other types of healthcare facilities. Shifting then to the restaurant, the fast food restaurant industry, there's a lot of drama with this, a lot of background history with this. You might recall that last year, there was the FAST Act that was enacted, which was AB 257. That created this fast food council that was going to have binding authority to establish wages and working conditions in the industry. There was industry groups got together and they put a referendum on the ballot, for this month. And then that suspended the implementation of that. Then AB 1228, an original version, was introduced, and then everyone started talking on compromise. So this reflects a potential compromise between last year's bill and potentially moving forward. So it will repeal the prior law that still hasn't gone into effect if the referendum is withdrawn. And so at a very high level, because a lot of you might be like, this doesn't apply to me, but if it does apply to you, you should definitely pay attention to it. It does establish a fast food council, but it has some very prescriptive responsibilities and duties with what they can do and how they're supposed to operate with that. So that is kind of interesting development in that particular space as well. A few other laws to note, kind of miscellaneous, but nonetheless quite important to note for folks. I think they'll have some very interesting developments for us as we work through the next year. SB 428 actually doesn't become operative until January 1 of 2025. But it puts into place a provision or some procedures for an employer to seek a temporary restraining order or protective order for an employee who has suffered harassment. And so, some employers like to have that available or feel that they need to take steps or can assist an employee in this particular space. So we have these provisions in there that will guide us through that process. Under AB 594, I just thought this was kind of interesting, labor code alternate enforcement. So up until January 1 of 2029, so 5 years, a public prosecutor can prosecute an action, either civil or criminal, for violation of specified provisions of the labor code. So that's kind of interesting. And then AB 933 added a provision to the civil code. We have a provision in there now that that already addresses whether certain complaints about workplace harassment are privileged and therefore not subject to civil suit. This adds section 47.1 that makes it clear that a communication made by an individual without malice regarding an incident of sexual assault, harassment, or discrimination is a privileged communication. And so the person that is alleged to have engaged in that conduct cannot proceed against them with some sort of defamation action or other civil action. As a sort of public service announcement as well, let us not forget, unless you are in one of the industries that has its own industry orders, that as of January 1, 2024, the salary inflation index for the basic exemptions, to be exempt from our minimum wage and overtime, sorry, not minimum wage, but the overtime and other labor code provisions is going to go up to $66,560. So keep that in mind. And the computer professional exemption is also increasing to $115 $763.35. So keep those in mind. Evaluate your salary and your pay for these folks so you don't inadvertently lose their exempt classification. And then before I hand it over back to Carolyn to talk about some Supreme Court decisions, both that were handed down this year and that we're eagerly awaiting a ruling on for next year, just wanted to point out a couple of bills that were introduced, got a little bit of traction, got definite interest among the employer community, which were passed the legislature, but Governor Newsom actually vetoed them. And he did provide veto messages for all of these in case you have the spare time and you want to look at them. But if I had to generally summarize the reasons for his vetoes, they tended to involve concerns about the implication and cost on smaller employers, and questioned whether they were really needed given the current state of some of the laws. Now, we've seen this happen before where Governor Newsom vetoes a bill that gets passed only to see it kind of revised, reintroduced next year, and ultimately enacted. So I think this is perhaps an interesting roadmap to what we can expect to see next year. A couple of things were discrimination based on family caregiver status, based on ancestry, which included caste discrimination. There was a provision that passed but got vetoed involving paid family leave to our employees. There was a provision, SB 627, which would have actually amended the Cal-Warren Act, which hasn't been amended in a very, very long time, regarding the notice provisions that needed to be provided to impacted workers. There was also kind of similar about displaced grocery workers as well. And then SB 731, I thought was pretty interesting, particularly since I like accommodation issues, but that would have addressed the issue with employees who were allowed to work from home or required to work from home during the pandemic. And now as they're facing requirements to come back to work, but are now saying that they need to continue working from home due to an because they need it as an accommodation due to a medical condition or disability. This would have put in place certain notification requirements, with respect to those requests. So a fairly discrete issue, but again, would be pretty interesting to see kind of how that all plays out next year. So with that, I will transfer the baton again to Carolyn to first talk about Supreme Court decisions from this year.
Okay, so we have three major decisions that came down, which you all might already be familiar with. So I'm just going to go through them really quickly. The first one is Raines versus U.S. HealthWorks Medical Group. And that is a case in which a healthcare or health services provider had been doing checks, pre-employment checks on medical and physical of applicants for employment. And the applicants alleged that the questionnaires during the screening were asking questions that were intrusive and overbroad, and they brought a class action. And the question for the Supreme Court was whether this third-party health screening entity could be held liable under FEHA for alleged violations of FEHA. And the Supreme Court answered yes. Third-party providers acting as agents for an employer can be held directly liable in addition to the employer. That was a very interesting decision in light of a previous lawsuit that was decided back in several years ago, Goon Wardeen versus ADP LLC, in which a payroll entity, ADP, had escaped potential liability as a third party for wage violations. So it really depends. You know, the Raines decision was under FEHA. The ADP decision had different causes of action for breach of contract, negligence, and negligent misrepresentation. So maybe that's what distinguishes. But it is a very interesting issue to see whether there can be joint liability for third parties for employment lawsuits. The next case that came down relating to arbitrations, and that's the Adolph versus Uber Technologies decision, which I'm pretty sure most everyone knows if they have arbitration agreements that have collective representative class action waivers in them. The Adolph decision followed on the heels of the U.S. Supreme Court's Viking River Cruises decision, and further clarified the question of whether an aggrieved employee who has an arbitration agreement, if they are sent to arbitration, can they still have standing to pursue a PAGA non-individual claim on behalf of other individuals in court? And the U.S. Supreme Court had said, no, they can't. They don't have standing. But Justice Sotomayor, in her concurrence, had kind of teed up this issue for the California Supremes. And the California Supremes held that the aggrieved employee did indeed have standing to bring a non-individual claim in court. Now, the question is now whether a employee that is sent to arbitration for his or her individual claims has to have the court claim stayed pending the arbitration, because the Adolph decision basically confirmed that if the individual is not considered an aggrieved employee, then they cannot pursue the non-individual claim. So that militates in favor of a stay. I think that some courts are going to stay and others are not going to stay, but it is something that's continually developing. The third one is the Cusiemba versus Victory Woodworks case, and in that case, it was a pretty rational decision. Basically, it held that the Workers' Comp Act does not preempt a negligence claim brought by the spouse of an employee for damages as a result of having gotten COVID-19. And so the spouse does not have the ability to bring a workers' comp claim. They can bring a negligence claim, and that the workers' comp statute doesn't preempt it. But the Supreme Court held that the employer doesn't have a duty of care to the spouse of an employee. So whether they can, state a claim is not. They probably can't. Next slide. Now I'm going to transition over to the cases to watch, and I'm going to go through them real quick. There are a whole bunch of them, but some of them have been on the court's docket. And I think like the first one, for example, this Bailey versus San Francisco District Attorney's Office, I think we talked about this several years ago at another one of these buckle ups. It's still pending oral argument, though review was granted 3 years ago. So, and this one is an interesting one because it is a case in which the Supreme Court is tasked with deciding whether a single incident of a racial slur is susceptible to a summary judgment as a matter of law. And the underlying in the Court of Appeal, the Court of Appeal upheld a summary judgment in favor of the employer in this case. What happened was the plaintiff was working at the DA's office in San Francisco, and in January 2015, after a mouse ran through the records room and startled her, one of her coworkers said, "You bleep N-word is so scary." and she brought a harassment claim. And so, this is an interesting decision. We'll see how the California Supremes come out on it, particularly in light of the Government Code 12939 regarding the single incident of harassing conduct is sufficient to create a tribal issue. And that is in the sexual harassment context. And that statute went into effect back in 2019. The Supreme Court granted review in 2020. All of the Bailey facts happened before the California legislature passed that single incident of harassing conduct statute. So we'll see. It still isn't, the case is still not set for oral argument. We'll see when the California Supremes get around to deciding it. The next one is, the next two are in the PAGA context. The Turrieta versus Lyft case is one in which there's a split of opinion amongst the courts of appeal on the resolution of concurrent PAGA cases. In one case, the Urabi versus Crown Building Maintenance Company case, the Court of Appeal held that the plaintiff in a first filed lawsuit, who was not a party to a second settled case, had a pecuniary interest in preserving her own PAGA case, and she had the right to intervene in the settled case and object to that settlement. In contrast, this Turrieta case, which is pending before on review to the California Supreme Court, Turrieta versus Lyft, the Court of Appeal held that the two appellants' status as PAGA plaintiffs in separate actions did not confer standing to move to vacate the trial court's judgment or to challenge the judgment on appeal in the Turrieta case. So whether the PAGA plaintiff and a representative action can move to vacate a judgment that purports to settle the claims that a plaintiff has brought on behalf of the state, that is the Supreme Court is anticipated to settle that issue between the two courts of appeal. The Estrada case versus Royal Carpet Mills is another PAGA case. This one is set for oral argument this month in a few days, in about a week. And this one is a very closely watched one because this one is going to purportedly settle a conflict of decisions between the 2nd District and the 4th District Courts of Appeal. The 2nd District decision is the Wesson case, and the Estrada case, which is the one that the Supreme Court has taken up review on, is in the 4th District, which is San Diego, Wesson being in Los Angeles. And this is on the question of whether a court can strike a PAGA claim based on manageability grounds. And there's the Wesson case held that the court can do that, and the Estrada case held that the court does not have the inherent authority to strike a PAGA claim based on manageability. Now we have the wage and hour cases. The first is the Eloff case versus LaPile. That case involves the issue of whether the employer has an affirmative, to demonstrate that it affirmatively took steps to ascertain whether its pay practices comply with the labor code and the wage orders, to establish a good faith defense to liquidated damages under the labor code. And then the second issue is, may a wage claimant prosecute a paid sick leave claim under Section 248.5B of the Healthy Workplaces, Healthy Families Act in a de novo wage claim trial conducted pursuant to Labor Code Section 98.2. What's interesting is that those two questions, while very important, were also, they don't address other issues that were raised in the Eloff case, mainly that a individual management or CEO or executive or board member can be held liable for wage violations in accordance with Section 558, and I forget the point, which one, I think, of the labor code. The second wage and hour case is the Camp versus Home Depot case. That one is very closely watched because that one will purportedly settle the issue of whether neutral rounding is permissible to calculate the work time for payroll purposes. And I think that in that decision, you know, we counsel employers that if you have the ability to pay for exact time, that is the preferred method. Don't fitz around with neutral rounding and all of that, even if it would be considered neutral. Next slide. And then we finally, in the wage and hour space, we have the Huerta versus CSI Electrical Contractors case. And that one pertains to whether the compensable time when folks are purportedly just kind of waiting around and standing around. So that one is very committed to the facts. If you're in the security industry, this is one to definitely watch. And the Supreme Court is going to hopefully bring some clarity to the issue. Next. Okay, we have 3 arbitration cases on deck in front of the Supreme Court. 2 of them dealing with unconscionability, and then the third one dealing with a waiver of arbitration. The Ramirez versus Charter Communications case deals with whether a provision in the arbitration agreement allowing for recovery of interim attorney's fees after a successful motion to compel arbitration is substantively unconscionable. And then the Fuentes versus Empire Nissan case is it involves a very common arbitration agreement used by car dealerships. And there are lots of different fact-based kind of issues relating to unconscionability. There seems to have been some conflict between the panelists in the Court of Appeal about whether the use of a certain type of font, the smallness of the font constitutes unconscionability, whether procedural or substantive. And the question again has arisen as to whether an employer's unilateral ability to change the arbitration agreement is something that renders it unconscionable, and other issues relating to that particular agreement. I think it's well worth reading through to see if your agreements may have some of the same factors involved in this Fuentes case, because it covers quite a bit of relatively common form arbitration agreements. And then finally, the Quach versus California Commerce Club, which deals with whether a party has waived its right to compel arbitration by engaging in litigation. And so at this point now, the Supreme Court the U.S. Supreme Court has decided that that prejudice does not have to be shown in order to claim the waiver. And so the California Supreme Court is now going to apply that decision here, and then talk about whether in that case, in the Quach case, whether the company or the employer that engaged in discovery, et cetera, had waived its right to compel arbitration. Okay, and then we have the Castellanos versus State of California case, which is is to decide whether Prop 22 is unconstitutional. And Prop 22, for those of you who are familiar with the app ride, Uber and Lyft, that is the statute that relates to them as independent contractors. Okay, so Lara's displaying the SHRM activity codes in order for you to claim credit. And I guess we are out of time.
We are
and
out
we
of
have
time.
so many questions.
We will
So-
respond after this to those who have submitted questions. We will get those, and Carolyn and I will get back to you. Those are apologies for not being able to address them now, or perhaps some of them were already answered. But we want to be mindful of everybody's time with this. Thank you so much for your attention and patience, and hopefully this was helpful. You will be getting the materials after this, as well as information on CLE if that is relevant to you. So thank you, and with that, we'll conclude our webinar.
Thank you.